Well, welcome to Broker Chat. I am glad that you guys are here, and I'm glad you took the time to join me today. And I'm going to go over a couple of important items that hopefully you can see. Anyway, what we're here to talk about today are the conventional loan exhibit. This also includes FHA and VA. And I want to point out something that is new, that's a separate paragraph now in these forms. And I'm not quite sure you all are aware of this, but I want to make you aware of it so that you can use it here. Can everybody see the conventional loan exhibit form? I sent it to you in your chat.
Oh, okay.
Let me see if I can pull it up on my screen share.
Okay.
Here we go. Can you see this okay now, guys?
Yes.
Okay, super.
Yes.
All right, so as you know, we had a few tweaks to some of the GAR forms this year, and this is something that I want you all to take note of for best practices moving forward on any of your finance exhibits. And it's a new paragraph, number 6 at the bottom of this form, buyer to notify seller of intent to proceed. So how many of you guys currently are doing that? I take by your silence that no one is. So what this now means is that it says when it is known, the buyer shall promptly notify seller of any mortgage lender to whom the buyer has sent a notice of intent to proceed with the loan application and the name and contact information for the loan originator. Okay, so best practice here, guys, is that we need to send on the GAR form notice. We need to send this information, and then if you will get with your lender, the buyer has to sign a form stating of their notice to intent to proceed before the appraisal or anything can be ordered. So that is a form that your lender will have. And I'm asking you now to get a copy of that, attach it to a notice form with the name and contact information for that loan, a loan originator, and send that to the seller. Because failure to do that could result in your buyer losing their earnest money. So let's just say, for example, the buyer gets turned down for their loan within their financing contingency. Okay, all legitimate, all within the time frame. However, as a good listing agent, if you have not sent that notice of intent to proceed, I'm going to tell you that you were in default and that your buyer is going to lose their earnest money, even though they received a loan declination within the proper time frame. I took a class with an attorney, and this was a big topic of conversation. And so I wanted to bring that to you guys to the table. Sorry, my phone doesn't stop because of class. But the closing attorney said that could be a definite reason for the buyer to lose their earnest money if the notice of intent to proceed was never sent. Okay, so this is an additional step that you're going to have to make part of your process when you're representing a buyer Or if you're a listing agent and they haven't sent you this letter, notice of intent to proceed, you should probably ask for that. But if you don't receive it and you don't ask for it and it wasn't done, and even though the buyer may have been sent a loan declination letter within their proper time frame, they could still be at risk of losing their earnest money. So I want to make sure that all of you guys understand this, and now would be the time to ask me some questions about this. This paragraph is part of the VA loan exhibit, the FHA loan exhibit, and the conventional loan exhibit. You can get from your lender the form that they have the buyer sign of their intent to proceed, attach it to the notice form, send it over to the other agent.
So Tom, that notice form, that's a GAR form?
It is a GAR form.
Okay, okay.
It's just called notice. Now, guys, this is a great form. Notice is a great form to use for lots of different ways of delivering notice. We're so accustomed to sending an email or a text and thinking that that's sufficient. But I got to tell you, we're going to have to buckle down in 2023 and be better at everything that we do, including our contracts.
And one other question, Tom, you said we get that the notice to proceed from the lender. So the lender has that form and then we attach it to our GAR notice form.
That's what I would do. That would be my best practice if I were you. All that you're really required to do is send them on the GAR form notice that the buyer has proceeded with their loan process, and here's the name and phone number and email address of the loan originator. That would also cover you, but I say go a step further and get that letter of intent to proceed from the loan officer and send that along with your notice. That to me is best practice.
I'm sorry, Tom, you said to send that when?
It says it needs to be sent as soon as it is known. Now,
Okay.
you know that, I mean, we're on pretty tight timelines for lending. So that buyer should be ready to notify their lender of their intent to proceed once you go binding. So it really, in my opinion, should happen early on in the process, because otherwise the loan's not going to get processed, the appraisal's not going to get ordered, and you're going to be dead in the water.
Okay. Yeah, it may happen so quickly. It can even be sent with proof of payment for earnest money.
Absolutely.
Tom,
Yes.
hey, this is Amy Tozer.
Hi,
Is this something that's new, or is this something we just haven't done, but we should have been doing?
It's something that we have not done, that we should have been doing all along. But now that it's a separate paragraph, it really brings home the whole importance of doing this.
Okay.
Because I got to tell you, we review a lot of contracts in the compliance department, and no one has documentation like this in their file. No one. So I'm trying to educate you guys now early on in 2023. Now we're going to be in March here next week, or this week, I guess. So we need to be doing this starting like immediately.
Hey, Tom, can I ask a question?
Of course.
Hi, it's Audrey Bankhead from KW Buckhead.
Hi, Audrey.
Hello, nice to see you.
You too. Well, I don't see you, but it's
I know,
nice
well,
to hear you.
Yes, nice to Zoom with you. I'm curious, if we have named the lender on this exhibit with the contact information and there's no change, do we still need to issue that notice?
It depends. Now, if the buyer already has signed the intent to proceed, I would certainly send that anyway, as part of paragraph 6. Because I got to tell you, there's some pretty smart agents out there, and they're going to use this against you if you don't do it.
Okay,
I think it's going to set you guys apart from the pack. Honestly, I really do, because I don't think a whole lot of brokers are going over this fine detail like we are with you all.
okay, thank you.
And it could be, honestly, it could be a good case if you're a good listing agent. If the other side doesn't do this and they terminate lawfully within the timeline, you could still go back and say, well, you all are in breach. You never sent us notice of intent to proceed. So we want the earnest money. Kind of helps in some way, in my mind. It kind of helps the seller for having their home off the market for, probably close to 30 days. So
Thank-
anyway, that is on all of the forms, and I want you all to start doing this like right now.
Tom, this is Susan Hawkins. I've got another question.
Sure.
What you were just saying about if they were to want to back out and terminate during due diligence, and then we say, well, you never sent intent to proceed. I mean, could they just easily say that they hadn't signed that yet because they were still in due diligence?
If they're still in due diligence, they may or may not have signed the intent to proceed with the lender.
Okay.
And again, what this paragraph says is it says when it is known. So there's not a clear-cut date, but it should be as when it is known. But you all know as well as I do, once you go binding, you've got to start that loan process.
Right. Okay.
So are there any other questions? This is probably one of the more important things that came out of the 2023 GAR form changes, in my opinion. Okay, no more questions. I'm going to stop sharing this and bear with me. I'm going to pull up another form. Okay, guys, this is the other form I want to go over with you all today. There's a lot of misunderstanding and really not good contract writing and files regarding a closing attorney holding earnest money. Okay, so the first thing I want to point out is at the top of the page, it says the closing attorney it's in right under the exhibit section. Closing attorney must still consent to serve as the holder using the F511. So there are two forms. If you are a listing agent and you get the closing attorney acting as holder of earnest money and you don't have the agreement signed, guess what? That's a problem. I have had issues where a closing attorney gave the earnest money back to the buyer wrongfully, and they used the excuse that they never agreed to hold the funds. Well, they had a good point. So make sure that both the F510 and F511 are signed and executed before you accept that contract. We want to make very clear who is holding the earnest money. And you all, if you've been in any of my classes or on this call before, you know how I feel about it. Closing attorneys should never, ever hold earnest money. You have a broker who has a trust account that should be holding your buyer's earnest money. Okay. I have had so many issues with closing attorneys making the wrong decision about who gets the funds if there's a dispute. Some just will automatically interplead it into the courts. They don't want to deal with it. I've had an attorney recently up in Cobb County who said, well, if I'm going to have to write a 10-day letter, I'm going to start charging you guys for my attorney fees, and there's not going to be any money to fight over. Well, that's all good and fine. However, that attorney agreed, when they agreed to be the holder, to follow this this GAR form, and it says they cannot charge for their services if they are acting as the holder. So, but what are you going to do? You're going to go to court and fight over it? It's just, you're better off having our offices holding the earnest money, because if there is a dispute, Eileen Smith, who works in my compliance department, will write the 10-day letter, and we will make sure, based on a reasonable interpretation of the contract, that the proper party gets the earnest money. Now, we don't play favorites. We're not allowed to do that. So sometimes our client doesn't get their earnest money back. But be very thoughtful about allowing a closing attorney to act as the holder of funds. But what I wanted to bring up to you today that you may or may not be aware of is paragraph 8, closing attorney holding earnest money in an all cash transaction. So do you know that if you have an investor who's paying cash for a property and you're allowing the closing attorney to hold the funds, if that deal doesn't close and if there is a dispute over the earnest money, this paragraph says that they don't write a 10-day letter. They immediately interplead the funds. So no one's going to get anything if that's the case, because once they deduct their reasonable attorney costs and fees, which they are allowed to do in an interpleader, there's not going to be any money left, guys. So if you've got an all cash transaction, please do not let a closing attorney hold the earnest money for your client. So were you all aware of that fact? Any discussion about that? I'd love to hear.
So Tom,
Y'all will be an awfully quiet today.
well, I have a question. This is
Okay,
Chris.
Chris.
Okay, so like when the a lot of investors or something like that, they'll say that the money has to be held by their attorney who's already done the title search and everything. So how do you handle that? If they just adamant that no, your brokerage cannot hold the earnest money, it must be held by the closing attorney.
I think all that you are required to do is go over that paragraph with them and let them know that if there's a dispute, that money's going to be sent to the courts and they're not going to see a penny of it.
Okay.
And then they can decide. I mean, it's their choice. It's their money. But our job is to notify them of what this form says. And the form says that in the event of a dispute regarding the earnest money and an all cash transaction, and where the closing attorney is representing the buyer or the seller, the only remedy available to the closing attorney to resolve the dispute regarding the disbursement is to be interpleaded into a court of jurisdiction.
Okay. Thank you.
You're welcome. All right, and then one final thing. This is probably going to be a short broker chat today, but I think it's an important one for those two reasons. But I still think that there are a lot of uncertainty with agents not knowing. Let me get out of this screen share. There we go. I think there's still a lot of uncertainty with agents not understanding the process of when earnest money is either not collected or where there's a dispute and I, as your broker, am holding the funds. So let's talk about an incident that happened just this weekend where we had a client who was an investor who put earnest money was due in 5 days, and the due diligence expired before the earnest money was due, which was not a good way to write that contract. And they found, a lot of issues with the property and they terminated. Okay. And then they decided they didn't want to tender the earnest money because they had zero due diligence. So before the 5th day, when the earnest money was actually due, they terminated the agreement and said, we're not paying the earnest money. So what I advise the agent is that what we are required to do as the holder is to notify the other party that the earnest money was not received, or it was the check bounced. And we are to notify the other party and our client, the buyer, and the buyer has 3 banking days to make good on the funds. And if they don't, on the 4th day, the seller can either terminate the contract, and in this case, it had already been terminated. And so they don't have any recourse if this buyer decides they're not going to make good on their promise to deliver the earnest money. But what that does is it protects the brokerage from any liability because we did our part by notifying all parties that we had not received the funds. Now, let's just say nobody notified me or the agent that the earnest, and the agent didn't follow up, and the earnest money had not been collected, and we did not send out that notice, then yes, we would be on the hook for delivering the earnest money. And then guess what? That'll be on your bill next month. So make sure that you understand how that works, because if there is and on the other side, if there is a dispute over the funds, the holder, which would be hopefully your broker, has the right to disperse the funds based on a reasonable interpretation of the contract. And in 25 years in real estate, I've never had to interplead earnest money. The contract always tells me who it should go to, and that's how that works. So any questions around that process? Because there still seems to be, and maybe because it doesn't happen to you very often, but there just still seems to be some confusion about what the process is if the deal falls apart and the parties can't agree, or if the earnest money is not collected in a timely fashion. So I want to make sure you all understand all of that. Are we good? Are we good on that?
Yep.
Okay. All right, guys, that's all I had to go over with you all today, but I am open to questions or anything else you'd like to talk about before we zoom off.
Tom, this is Susan West from West Cobb. How are you doing?
Hi, how are you?
Doing well, doing well.
Good, I'm glad you're here. We
thank
never get
you.
West Cobb folks.
Thank you. Good to be here. I look forward to these. I love the broker calls. These are my favorites.
Oh, good.
I wanted to find out a little about, listing, pre-listing kind of things, as far as marketing. And I know you can't really market it if it's, not, if it's coming soon, but can you go over the coming soon? It's like clear as mud to me. It just is.
Yes, I can. That
Thank you.
document, which is our seller listing agreement, allows us to go ahead and get the document signed so that we can represent our client. I am a firm believer in getting that document signed ASAP. I've seen way too many instances where we haven't gotten it signed because the listing's not going to go live for, let's just say, 30 days. And then something happens, or one of the neighbor approaches the seller and they understand they might want to sell, and then we get cut out of the deal, right? So I would go ahead and get that document signed. And then at the bottom of page 1 on that document, it says marketing commencement date. And that's when we are going to list it in the multiple listing services and really do the heavy marketing. But I will tell you that some agents go ahead and start the marketing process early before it's listed. And FMLS is, I don't know how they are finding out, but they are finding out somehow that so-and-so agent sent out some marketing material. And of course, then I get a letter and they're wanting their fee. Like, well, it was never, we never listed it. So you're not entitled to your fee. But just be aware that they are, I think their official rule, to be technical with you, is what, 18 days? I think. But listen, I'm pro seller, pro agent. So get that document signed to protect yourself and your commission, and then start your early marketing quietly. Because we work for the seller and we want to do the best we can for them. But also on that same note, understand that the more exposure we provide for that listing, the more opportunity that seller has to get more money for his house if they get into multiple offers. So trying to not put it in the system is not helping your seller.
Yeah, and the off-market stuff, that I hear about, you hear about the off-market properties, it's coming, that's kind of, to me, a little gray sometimes.
Well, I think that agent thinks they're doing their seller a good service, maybe, or maybe all they're interested in is a quick commission. But you're really not doing your seller a good service by not exposing it to the market and to agents who might have buyers for it. So who's to say if you are quietly, if you're quietly marketing a property and it goes under contract, you might have shortchanged your seller for, who knows what kind of money, right?
Right.
So I really believe in protecting yourself first. If they're not ready, they need to get ready, and they need to get the house in FMLS and Georgia MLS right away, because you're going to have more exposure and more opportunity to get the most money you can for that seller.
And how long can it be on a coming soon status?
18 days.
Okay, that's what I thought. Okay, thank you so much. I appreciate it very much.
Absolutely. And hey, here's another thing. Why not put it in the multiple listing services is coming soon? Why keep it a secret? You know what I mean? Let's go ahead and get it in the coming soon. Just notify it's coming soon and start, getting whetting people's appetite about that listing.
Absolutely. Absolutely.
And then Tom, regarding coming soon, then you get tons of calls saying, can my buyer get in early? Or can I get in early? What's the response for that?
The response is everybody will have the same opportunity and the showing start on this date.
Okay.
And then what happens if the seller changes their mind and says, oh, I need 15 more days?
Well, it depends on where you are at with the process. So if you have it, let's just say you have it as coming soon, you're gonna have to take it down.
And just kind of
Because
start over?
FMLS will nail you if it goes beyond their time frame.
Yeah, so you have
So-
to take it down and then kind of relist it kind of thing?
Yeah,
Oh,
right.
okay. Okay.
Yeah.
Well, that
So
doesn't look
before
good either.
that's a really good question, honestly, but before you put it in coming soon, which I believe it should be in, I believe that it should go in coming soon if it's going to be coming soon. That way you've got a lot more exposure. And, but if you think that they're not going to be able to get it and just not be able to go active within that 18 days, then you probably shouldn't put it in coming soon until you know for sure that they're going to be ready.
Absolutely. Okay, thank you.
You're welcome. Anyone else have anything they want to talk about today before we adjourn? Gosh, y'all have been awfully quiet today. All right, guys. I'm always here. I'm a phone call away if you need me. I appreciate you taking the time to join me. I hope you got some benefit from today's call.
All right. Thank you.
All right.
Thank you
Thank
so
you.
much. Take
Thank
care
you,
now.
Tom.
Great day.
You too.